Mr. Green, any questions of this witness on child support?
I do. Are you answering these questions or is your parents doing it for you?
Nope, I'm doing it. I'm just looking straight behind them.
All right. I need you to be quiet and not answer. So stop talking.
Welcome to Rebel Chaser. My name is Gail, and I have a clip for you from Judge Thornton in North Dakota. He's hearing a motion for custody and another motion for child support, or a case for child support. And I cut out the child support questions because they're, where do you work, how much do you make, that kind of thing. I just cut that out. It was long and boring. And I left the rest in. Mom is very angry, and she's doing everything she can to keep her child away from her father. I'll let you guys watch.
All right. Sargent County District Court is now in session this June 26, 2024. The time is now 9:35 a.m. My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Sargent County. We are in the Sargent County Courthouse in the courtroom. We are appearing, at least we have some participants that are appearing by reliable electronic means. We are live streaming the event on the Southeast Judicial District's live stream YouTube channel. The courtroom door is open. The building is open. These are open and public proceedings. Any member of the public can attend these proceedings either by appearing in court in the gallery or by following along in the live stream YouTube channel. Case that the court's going to take up was scheduled for 9:30 a.m. this morning. It's Kristen Witkowski versus Zachary Opatz and the state of North Dakota as a statutory real party in interest. File 41-2023 DM37. Present in court for the petitioner is Erica Chisholm. The petitioner appears personally in court with her attorney. Likewise, the defendant or the respondent appears personally in court with his attorney, Jonathan Green. Appearing on behalf of the state of North Dakota, Attorney Jung appears by reliable electronic means with the court's permission. We're here for an interim motion hearing that was initially filed by Mr. Green. There was a counter motion filed on behalf of the petitioner thereafter in response. And so under North Dakota Rule of Court 8.2, the court notes that there have been several declarations that have been filed. All right, Mr. Green.
I will make a brief opening statement, Your Honor. In September of 2023, the parties in this case went their separate ways. You will, well, if you've read the affidavits and declarations herein, you know they haven't been back together since. Since that time, my client has seen the child on 4 occasions, but has been largely withheld. And the child's being withheld unless my client follows Ms. Witkowski's rules. Now, it's interesting in her declaration, you've seen how my client, she portrays my client as this controlling individual. But who's controlling this situation? Who's controlled it since September of 2023? She has. Today, we're asking that the court award my client temporary interim relief, awarding my client temporary primary residential responsibility until a full evidentiary hearing can be had. And under normal circumstances, I would probably say, Your Honor, let's just do 50-50 until we have the full evidentiary hearing, especially in situations where a child is this age. We don't have a school issue that's going on here. We don't have a number of things that happen when kids get a little bit older, which make issuing an order for 50-50 a little bit more difficult. It does happen a lot, but it's a little more difficult when you have those complexities. Here, we don't have those. So why am I asking for a temporary order on behalf of my client to be awarded primary residential responsibility? I'm doing that because he hasn't seen the kid in months. She's withheld him. She's controlled all of this. She asserts in her declaration that she was concerned that he might do the same thing. Well, she never gave him the opportunity. And you're going to hear through her testimony and through cross-examination today that this was all planned the day she left. This wasn't something she did because of some threat by my client, as she states in her declaration, to withhold the child from her and that she'll never see again. In fact, the court, if it's reviewed any of the exhibits, would not find that anywhere in those exhibits. Through cross-examination today, I fully intend to show how Ms. Witkowski is talking out of both sides of her mouth. There are a number of very inconsistent statements that make the entirety of her declaration unreliable. And as I've noted in my objection, there is a plethora of hearsay throughout Ms. Witkowski's declaration, which I will dive into through on cross-examination. Your Honor, I have already submitted our proposed interim order, and I am asking the court to issue an order consistent with that proposed interim order. Thank you.
Ms. Chisholm, any opening statement?
Yes, briefly, Your Honor. These are two young individuals who have a child that, as evidenced by the declaration of my client, have a 1.5-year-old child that has some substantial developmental disabilities that were present at birth. My client has put in a lot of effort into addressing these developmental disabilities by way of an early interventionist at Ann Carlson. She has been attending to the minor child's motor deficiency needs. Mr. Opatz has had access to these appointments since this child's birth. He's had access to the child's online doctor's appointments, the child's online medical records. He was informed of the Ann Carlson appointments. He's been informed of the WIC appointments. He's been informed of the child's early intervention appointments. He's had access to be involved in this child's developmental needs, but he has chosen not to. He's had access to this child by way of visitation, and he has chosen not to. This has been a control issue with respect to Mr. Opatz, not with respect to my client. He has made it very clear that from the moment that the parties went their separate ways, that if my client left with the child, that she would never see the child again. He has made it very clear that the only type of parenting time that he was going to exercise was going to be 50-50. Otherwise, quite frankly, he was not interested in exercising parenting time. Opposing counsel has argued that he's not had the opportunity to exercise parenting time. That's untrue. He had an opportunity, and during that opportunity, he tried to flee with the party's minor child, and law enforcement was involved, creating a traumatic experience for this child. Quite frankly, these are two individuals who don't trust each other. They don't trust each other with respect to their child, but this is a child that has substantial developmental needs and needs a stable, consistent environment. And right now, it has been my client who's been the primary caretaker for this child. She was the primary caretaker during the party's relationship. And unfortunately, Mr. Opatz has made it clear that rather than addressing the child's needs, he's more interested in exercising a 50-50 arrangement. And that's where we're at right now, Your Honor. This is not a control issue. This is a safety and welfare issue for this party's child. And that's the primary concern for my client. It's not about denying Mr. Opatz the ability to see his child. He has the ability to, or has had the opportunity to support the child. He has not taken advantage of that. He's provided some wipes and some diapers over the span of the last 9 months. That has been his contribution. My client has given Mr. Opatz the opportunity to be involved, but because it has not been on his terms, he has not been interested, and that's why we're here today, Your Honor. Thank you.
All right, Mr. Green, call your first witness.
I'm limited to cross-examination, so I'll call Kristen Witkowski.
All right, Ms. Witkowski, I'll remind you that you remain under oath. You need to come and sit in the witness chair. Adjust the microphone so it's close to your mouth. And Mr. Green, go ahead.
Ms. Witkowski, you submitted a declaration with the court, correct?
Yes,
And did you draft that declaration or have assistance drafting it?
I drafted it by myself.
Okay. No assistance?
No assistance.
Okay. And so if you drafted it yourself, then you read through it prior to
Yes,
your.
I did.
All right, ma'am. This is the third time that I've asked you to just slow down. You really need to slow down and listen for the question. Mr. Green will ask one question at a time. You need to wait for his question to be completed before you start answering. And he will do the same. He's going to wait for your answer before he starts asking his next question, okay?
Mm.
Is that a yes?
Mhm.
Okay, so when you use words like mm-hmm and uh-huhs, we don't understand those on the record. So is that a yes?
Yes,
All right, Mr. Green.
Thank you, Your Honor. So since you drafted it yourself, it's safe to say that you had an opportunity to review the entirety of your declaration before your electronic signature was added to it.
yes,
And do you understand the importance of being truthful in your declaration?
yes,
And were you truthful in your
Yes.
declaration?
yes, I was.
All right. I'm going to start off in paragraph 2 of your declaration. And perhaps it's not even in paragraph 2, but at one point in your declaration, I just want to make sure we get this cleared up right away. You indicated that you notified Mr. Opatz that you have a new address.
Yes,
When did you do that?
as soon as I got it.
And let me back up. When is the last time that you and Mr. Opatz have spoken to each other verbally, with not text message, but verbally?
We've had FaceTime back in December so he could see Cassidy.
And that would be December 2023.
Yes,
Okay. And all of the communications since December 2023, how have they been?
they've
Writing
been,
or,
they've all been over Facebook Messenger.
and to be clear, it's been nonverbal, it's just been in writing, correct?
Yep.
All right. So now I'm going to go back to the address situation. You had indicated in your declaration that you notified Mr. Opatz of your new address. Did you do that through Messenger?
I had sent pictures of everything to our attorney because my attorney had told me to do it that way to make it safe for everybody.
So you didn't send it directly to Mr. Opatz, you sent it through your attorney?
Because we were told to send it through our attorney.
I'm just asking you a yes or no question. Is the answer to that yes, you sent it through your attorney?
Yes,
Are you aware that your address has not yet been updated with the court?
I gave it to them,
You gave it to who?
my attorney, to do with everything they were supposed to.
So you don't know if your attorney actually passed your address on to me or Mr. Opatz?
She did
Okay, how do you know that?
because I was told.
Okay. But were you aware that your address isn't updated with the court?
I didn't know they hadn't updated it.
Okay. Did your attorney tell you that she updated it with the court?
Your Honor, I'm going to object. That's attorney-client privilege.
Oh.
And it's been asked and answered.
I'll sustain the objection. Mr. Green, let's move on.
Okay. It indicated in paragraph 3 of your declaration that Zachary gets upset and argumentative when he doesn't get his way. When was the last time that happened?
Right before I left
And when was that?
in September.
Okay.
September of 2020 what?
Three.
Thank you.
And I noted the one-sided argument. It makes sense, but you understand that it takes two people to have an argument, correct?
I'm not admitting that I didn't argue, but he was the cause of a lot of them.
Okay. Now I'm going to ask you to answer my question. Would you agree with me that it takes at least two people to argue?
It does, but
Okay. But you blame Zachary for the arguments, don't you?
I don't blame him. I said that he is that starts them all.
In paragraph 3, you go on to state, I have messages where I text him pictures and answer to his questions.
I have.
When was the last time you sent him any pictures?
I've just sent him some in December of her starting to walk with an A-frame.
So 6 months ago.
Yes, because he hasn't asked for any.
Okay, so you only send him pictures when he asks for them.
I sent the ones in December out of being excited for her to be starting to walk, and wanted him to see it.
You also made a comment in paragraph 3 that I have not ignored him. What did you mean by that?
If he asked something, I tried to do it, or I tried to help him figure out what his problem was.
Okay. But isn't it true that Zachary has repeatedly, more than 50 times since December, asked to see your child and you have not responded to that?
By our lawyers telling us not to.
In contrast, anytime Mr. Opatz messages you and said, I have diapers or wipes or something for you, you immediately responded, didn't you?
I responded to those, but I didn't need them right then and there. Because we had just bought a box.
So that's a yes?
Yeah.
I didn't hear that.
Yes.
In your declaration, you also indicated that Mr. Opatz hadn't contributed financially to your child since, when was that? Do you recall?
At least September of 23.
Okay. I'm a little confused because didn't he pay for daycare for a while even after you left out?
Maybe once, and then he quit,
But that would be a financial contribution, wouldn't it be?
and then he started paying, and then he quit again.
I just need you to answer the question. That would be a financial contribution.
Yeah,
Okay. And then he's bought diapers, correct?
only 2 boxes.
He bought diapers, correct?
Yeah.
In your statement and in opening counsel's opening statement, it was stated, and you stated, I have offered Zach parenting time, as I said, but he will not agree to exercising parenting time unless it is parenting time schedule that is 50-50. You wrote that, right?
Mm-hmm. Yes.
When did Mr. Opatz say that he would only do it for 50-50?
He's said it from the beginning of when I left.
So September 2023?
Yes.
And did he say that verbally or in writing?
He had said it verbally and in writing.
And when did he say it in writing? Same time?
Yes.
In paragraph 4, you also went on to say Zach physically assaulted my mother while trying to drive off with the car with KJO in his car. You wrote that?
Yes.
Were you present when that happened?
I was at work at that time.
You were not present.
I was not.
Your Honor, I'd ask that the court not consider that it is hearsay.
Ms. Chisholm.
Your Honor, she has firsthand knowledge of what occurred because she read the police report.
Again, that's hearsay.
Sustained. The court will strike from the record reference to an incident at the church that comes to the plaintiff secondhand. Go ahead.
Thank you, Your Honor. You also wrote in your declaration, this tells me that Zach is not concerned about what emotional impact this might have on KJO, but rather concerned about his own personal interest. Do you remember writing that?
Yes, I do.
Okay. Isn't it true that you keeping KJO from having a relationship with her father is also harmful to her?
It is not harmful to her.
You think it's okay that she hasn't been able to see her dad in 9 months?
I'm fearing for her safety
Okay. And why are you fearing for her safety?
because he has threatened to take her and not let me see her
Okay. And how does that impact her safety though?
because he could run off to out of the states or into different states and I would never get to see her again. He has threatened that.
Okay. But I guess the question really goes to her safety. Are you worried that he's going to harm her?
He could.
Okay. He hasn't done it to date though, has he?
He has not, but she
You
has
didn't-
left him.
Hold on. You didn't put anything in your declaration about Mr. Opat's harming your daughter, correct?
Mm-hmm. Yes.
Clarify that question or the response to the question. When you say, Mr. Green asked, you didn't put this in there, you answered yes. So was that yes, it's in there, or yes, I didn't put it in there? So it's not in there.
I didn't put it in there.
All right, thank you, Mr. Green.
Thank you, Your Honor. And you had also indicated, and it was also said in the opening statement, that Mr. Opatz would only see the child on his own condition. You recall writing something like that?
Yes.
But isn't it true that you were only going to allow him to see the child on your own conditions?
No.
Okay. Then why, then whose conditions were you following?
I was following what my lawyer had told me to do.
Okay. So your lawyer was setting the conditions.
She had told me to be careful and work slow with her because of Cassidy's disabilities.
Do you believe that KJO deserves to have a relationship with her father?
She does, but under certain
I just need
circumstances,
you to answer yes or no to that question, please.
she deserves to have some.
Do you know, is there a difference between a child that's delayed and a child that has special needs?
Yes, I do.
What is the difference?
She is getting help with it. She's behind on walk. She didn't walk or crawl until she was almost a year old.
Okay, maybe my question was a little bit confusing. I'll try and re-ask it. I asked you if you knew the difference between a special needs child, and a child that is delayed. Is there a difference? And if so, what is it?
Your Honor, I'm going to object to this line of questioning. It's inappropriate question for a lay person such as my client.
Well, she uses both throughout her declaration, and that's why I'm asking it.
I think she can testify to the extent possible. The objection was based on lack of personal knowledge. The two terms have been used interchangeably throughout the declaration. The court is going to allow inquiry based on the witness's understanding of the two terms, and if they are synonyms or if they are some other, if there is a difference, she can explain what her understanding of those terms are. Go ahead, Mr. Green.
So I'll ask it again, and I'll even give a little bit more background. You've used the phrase special needs, referring to your child as a special needs, but you've also referred to her as being delayed. And so the question to you is there a difference between the two? And let me ask it maybe even a different way. Are you just using the two phrases interchangeably? I'm just trying to better understand your declaration. So I'm just wondering, if you meant the same thing when you referred to her as a special needs child or as a child that's delayed.
Yes, I did.
You mean the same thing?
Yep.
Okay. All right, so I'm going to ask you another question then. On paragraph 5, you stated, quote, Zach is not familiar with KJO and her day-to-day needs. He has no idea how to deal with her special needs that include language and motor skills. What did you mean by motor skills?
How she was not walking or crawling, and we have to take things slow, and it takes her a little bit to gather what you are saying and trying to show her.
Okay. Zach has another daughter, correct? Whose initial, correct?
Are the same.
He has another daughter though. That's not your daughter, correct?
Yep.
All right. And they happen to have the same initials, correct?
Yes.
All right. I'm pointing that out to the court because I was a little confused, and I suspect the court may have been. There was a part in there where you talked about KJO going to your parents. Were you referring to Zach's daughter, KJO, in that area?
She was, both of them went to my parents in this for help with watching.
Maybe a better example was your parents went to KJO's ball games. Remember saying something like that?
Yep.
In that instance, were you referring to Zach's older daughter?
Referring to both of them because our Cassidy was there too.
Okay. Now, Zach would not have had the opportunity since September 2023 to really work on the motor skills with KJO, would he?
He has when he has seen her.
He did it the 4 instances that you allowed him to see her.
And we went over the allotted time that we were told to.
Okay. So I want to be clear. I mean, the only reason that you want him to have supervised parenting time is because you're afraid he might take off with the child, correct?
And to get to know her. And then when he gets to know her, we can let him go on without the supervised visits.
But the reason that you claim he doesn't know her is because you withheld the child from him, right?
I was directed by my attorney to.
And that's what you did, right?
Mm-hmm.
And now you've alienated your daughter from her father, right?
I've not alienated her. I was doing what my attorney told me to do.
You just said you claim that your daughter doesn't know him. That means you've alienated, right? You're going to look at me. Don't look over here.
I'm not even looking at them. I'm looking at the wall behind them.
Okay.
I'm not even looking at.
Ma'am, you're free to come and go. This is a public hearing.
Would you agree with me that you claim your daughter doesn't know Zach because,
She knows him some.
and you want to now benefit from that, right? You want to have some parenting plan put in place where he needs to get to know your daughter as a result of the conduct you've done. That's what you want, right?
With help from her early interventionist and my attorney both said that would be the best for her.
Objection, Your Honor. That was hearsay.
Sustained.
Paragraph 6 of your declaration, you indicate I have provided KJO with a safe environment. If there was an emergency, would you have the ability to drive her to the hospital?
I am working on getting my license. I had to postpone it.
Hold on, you didn't answer my question. Without breaking the law, would you have the ability to drive her to the hospital? Yes or no?
No.
Mr. Opatz has his driver's license, correct?
Yes.
He'd be able to drive her to the hospital, correct?
Yeah.
And your nearest family, where do they live from you?
Not that far from me. They actually live in the same town as I do.
Okay. And where do you live now?
I live in Gwinner.
Okay. And so how long would it take for somebody to get there?
Maybe a minute or two.
Okay. So you would have potentially somebody to assist you with the ride.
Yes.
It would just take a minute.
Or I would even have somebody in my apartment complex to help.
I'm really trying to control the questions here.
You need to slow down and listen to the questions, please. I understand that you might be upset at this time, but you just need to take a breath, wait for the question to be asked, wait for Mr. Green to finish his question, answer his question and his question only. And he will wait for your response before he asks his next question, okay? Ma'am? Okay,
I was just breathing.
okay, good. Take a deep breath, wait for his question. Go ahead.
Thank you, Your Honor. Now, in paragraph 7 of your declaration, you state, quote, anytime KJO would fuss or cry, Zach would hand her over to me because he could not handle a crying baby. You wrote that, correct?
Yes.
Other than your statement in that declaration, do you have any other evidence that supports that statement?
I have seen him bring her to me when I would be trying to have some mom time alone.
Okay. Do you have any other evidence to support that? Zach always turns the kid over you when the kid's fussing.
Not with me right now.
Okay. In fact, in the very next paragraph, you state, this is in paragraph 8 of your declaration, I have witnessed Zach put on a show for others to see. When we would go out, he would often offer to take her and carry her diaper bag. You wrote that too, right?
Yes.
Doesn't that just contradict what you just said? That he never does it, but now you're saying he does it in public?
He doesn't do it in public, but if nobody's around, he will not.
Or did you just say that because you know there are others that have seen him take care of your daughter?
Nope.
All right. In paragraph, I'm going to jump ahead to paragraph 11. You write, quote, I have a fridge full of food from all of the food groups. My cupboards are full of healthy snacks and food for KJO to eat. You wrote that correct?
Yes.
What are the food groups?
You have your protein, which would be your meat, dairy, cheeses, vegetables, fruit, grains.
Okay. And what kind of snacks do you have in your cupboards?
We have like animal crackers. We have the fruit cups, puddings, her veggie puffs that she likes, her fruit melts that she likes, fruit snacks. We offer her choices.
Now, are these kid fruit snacks or just normal fruit snacks?
They are kid ones.
Okay. In paragraph 14, you stated, quote, KJO has many friends and acquaintances that share hand-me-downs with her, end quote. You wrote that?
Yes.
Does she have many friends or do you?
No, she has friends.
Okay. I'm just curious. She was 9 months old when you left. She's about 18 months now. How does an 18-month developmentally delayed child who can barely speak have many friends and acquaintances?
She has friends that she plays with at the park. And they have come to the house and played with her.
Okay, you also wrote in that same paragraph, you covered a lot of ground in paragraph 13. You said Zach has never paid for any of KJO's medical bills.
The state has paid for all of it.
Okay, hold on. That's a yes or no, correct?
Yes,
You said that.
yes.
Okay. So who has paid for it?
The state, because I had Medicaid and was not going to put her on his insurance at first.
So you also didn't pay for it, correct?
Yes,
She is on Mr. Opat's insurance at this time, correct?
I do not know that because he has not given me the information for it.
Okay. And if you don't know, you can say, I don't know. Okay. Have there been any uncovered bills?
No, there has not been.
Still in paragraph 13, you said, quote, I have texted him about her doctor's appointments when she was exposed to COVID. At times he did not answer me, and at other times he did, but then did not follow up and ask questions after the fact. You wrote that?
Yes,
Okay. I'm going to give you an opportunity to tell me specifically what follow-up questions would you expect Mr. Opatz to ask you after you've already told him about the condition?
to make sure she's okay and how her tests and stuff had come out.
So you wouldn't tell him if the tests were not good, he should just ask you?
I had told him that we were going to get her tested with her doctor to make sure. And he didn't respond back.
And did you let him know what the test result was?
I had told him that it had come back where she was negative.
Okay. So what else did you expect Mr. Opatz to follow up in that situation?
To see how she was doing afterwards, if she was still sick or not.
Well, you took her to the doctor because she was sick, didn't you?
We had taken her to the doctor for her.
Okay, I just need to answer the question. You
We
took her to
take-
the doctor because she was not feeling well, is that correct?
No, because we had taken her for her well checkup.
Okay, and then they
And-
suspected during that time that she had COVID?
My dad had COVID, so we tested her just to make sure she didn't have it.
So I'll ask you the question again, so, because you didn't answer it. When the test came back negative, you told him that. What follow-up question should he have asked after that?
See how she was doing.
About the wellness check then?
Wellness check or he didn't ask any questions.
Well, and the reason I'm asking you that question is, it seems like it's a catch-22. I've done this a lot of years, and some parents would say it's annoying that you ask how the kid's doing every 5 minutes, and we have other parents who say they don't ask enough. I mean, so I'm trying to figure out with you, you would prefer that Mr. Opatz asks you on a more regular basis how your child's doing,
Yes,
even though you've had problems with communications in the past.
I have put that in the past. I have willing to work with for my daughter and keep her safe and healthy.
Okay. It seems to me that you made a pretty significant issue about Mr. Opatz being absent because he was the breadwinner of your family. Is that a fair assessment?
No,
Okay, what did you mean when you said he was gone all the time?
he
Because he was
worked all the
working.
time or
You get to wait until,
Stop. You need to wait for the question. Ask the question again.
thank you. So what did you mean when you said he was absent all the time because he was working?
he wasn't always working though. He would go out and do things without us. Like he went on an ice fishing tournament in the end of January, multiple times with friends. And leave me at home with the kids.
So he was in multiple fishing tournaments in January?
He went to one in every January in Devil's Lake.
Now, I noticed in your exhibits, you submitted some text exhibits, correct?
Yes.
How come you just submitted like piecemeal stuff? Is that
Because
a
I
purpose?
I screenshotted them off my phone that I had. So I tried to get them in close as I could to where they were.
I'm going to have you grab the white book behind you there and turn to plaintiff's exhibit, sorry, defendant's exhibit 2, plaintiff exhibit 2. What are we here? Defendant's exhibit 2. Can you turn to defendant's exhibit 2? Do you recognize these?
I recognize my text messages.
And their text messages between you and who?
Zach.
Okay. And what's the date on page 1 of exhibit 2
This is September
of what year?
23.
Okay. And if you flip to page 37, what's the date at the very bottom of page 37?
28th of September.
Permission to approach, Your Honor?
Granted.
Oh, I was looking at the wrong page. I thought you said page 2. So that would have been April 4th.
That's 2024.
Mm-hmm.
I'd offer exhibit 2, Your
Yes.
Honor.
No objection, Your Honor.
Defendant's exhibit 2 is received. And I should note for the record, defendant's exhibit 2 is partially redacted, but not fully redacted.
I caught that, Your Honor. We're going to submit a different one.
All right, so this document is going to be filed as confidential, as not complying fully with Rule of Court 3.4. And the proponent of the evidence is ordered to submit a fully redacted copy. This provision or this exhibit will be filed or modified to be filed as confidential, including in the Odyssey file. Go ahead.
When I file the new one, Your Honor, will it receive a new index number or will this replace the confidential one?
It will receive a new index number.
Okay, thank you, Your Honor.
But just for the record and for sake of clarity, defendant's exhibit 2 is received. This document will be filed as confidential. The replacement document can't be modified in any way other than to redact the juvenile's name.
Understood, Your Honor.
All right. And that will be made part of the evidentiary record. Is that acceptable to you, Ms. Chisholm?
It is, Your Honor.
All right. Go ahead, Mr.
Thank you, Your Honor. Now, I noticed in your text message exhibits, you had indicated, and in your testimony here, your text message exhibits from December 19th, 2023, that's the day you took her into the doctor for the well check.
Yes.
Okay. And you submitted text messages from that day, correct?
Yes.
I want you to turn to page 26. You just testified that Mr. Opatz did not ask how she was doing. Turn to page 26 for me of defendant's exhibit 2.
And ma'am, just for your information, there is Page number is on the bottom of the exhibit, so it'll say page 26 of 37.
Yep.
All right.
Let me know when you're there.
I haven't been there for a while. I just said
Okay.
this.
All right, I want you to look, and you would have taken her to the doctor prior to what, 5 p.m.?
I had just gotten home from Fargo and was able to respond.
Okay. He did ask you how she was doing that day, correct?
He did, but I couldn't respond because I was taking care of my daughter who needed to have full attention.
And then the following day on the 20th, he asked about her getting tested for COVID.
And I gave her an answer.
Okay. I understand, yes, you did all of that, but your testimony earlier was that Mr. Opatz didn't even care to ask how she was doing after the doctor's exam, correct?
Yes,
He did though, didn't he?
just quickly.
Okay. You also have made a pretty big point out of Mr. Opatz missing a number of appointments, correct?
Yes,
That was a decision that the two of you made together, wasn't it?
I gave him the
It's a
option.
yes or no question.
No,
It's not a decision you made together.
I told him he had the option to go if he wanted, or he could go to work.
Well, then I guess I'm struggling here. You guys also had financial problems, right?
Because he said I could not.
You had financial problems, right?
Yeah,
Right? And so if Mr. Opatz takes off from work, does he get paid for it?
he could have used vacation,
Okay.
and that would have got him to be paid for.
That was one alternative, or you could take it off without pay, correct?
Mm-hmm.
That's a yes.
Yes,
Now, was another option that Mr. Opatz would take her to the doctor and you could work?
he had told me at that
Was
time.
that another option? I'm just asking you a yes or no question.
No,
Was it an option? Okay.
Mr. Green, while you're looking here, the time is now 10:52. We're going to take a break at 11. So if you can find a convenient place to break, it'll just be a short convenience break and then we'll be back on the record.
Okay, thank you, Your Honor. In paragraph 14, you stated, when I come home and told him what the doctor said, he did not follow through and would not do what the doctor said. How many times has that happened?
every time he would make her a bottle in the mornings.
Do you have a number? Days, times that would happen?
At least 30 times.
Okay. Provide me with 3 examples of when you came home from the doctor's giving you advice, and Mr. Opatz refused to follow doctor's advice.
When we had gone to the doctor in December January after she was born, they had told us, because she was having troubles going to the bathroom, to put Karo syrup or molasses in her bottle. And we told him multiple times and he was not putting it in there.
Okay, so that's one incident. You have another one.
But I think when we were trying the oatmeal, the rice cereal, we had to make them really mushy, and he was making them too hard.
Okay. And he was doing you think he did that intentionally?
No,
Okay. Give me a third example then.
when we were switching her from her bottles and all the sippy cups to different bottles.
what did the doctor have to say about that? And what did Mr. Opatz do that
He-
didn't comply with the doctor's orders?
He wasn't making sure that they were mixing right.
Okay. And you believe that was intentional?
I don't, but it could have hurt her with her weakened larynx.
Also in paragraph 14, you stated, quote, he has chosen not to participate in her medical appointments and Ann Carlson appointments. You wrote that, right?
Yes,
When did KJO start going to Ann Carlson?
in November
November of when?
23.
You had already moved out.
Mhm.
When did you notify Mr. Opatz?
That was a yes.
Yes,
Thank you, Your Honor. When did you notify Mr. Opatz that she was being seen at Ann Carlson?
I had told him over Messenger.
Okay. Do you have any evidence of that?
The evidence, all that I have is in the books.
You didn't submit any evidence today, did you?
No,
Did you use Messenger and text messages, Mr. Opatz?
I just use Messenger.
So exhibit 2, is that all Messenger then?
Yes,
And you said you told that to him when?
in November. We told him at not an intervention, a supervised visit in person.
Okay. So there's nothing in writing then, right?
I misspoke. I'll admit it.
What did you exactly tell him?
That she was because she was delayed, and her doctor had referred us to an interventionist, and I had told him.
Okay. Are those the exact words you used?
Yes,
You didn't let him know that it was Ann Carlson?
I told him it was Ann Carlson.
Okay. And what did he say in response to that?
He didn't say anything.
And do you have any evidence that this, other than your statement here today, is there any evidence that you ever had this conversation with him?
The person that that was there help facilitating it did chose not to be in court.
Okay. Would it be in her notes?
It would be up to Erica to.
Does that person take notes?
We were just letting him play with Cassidy.
Do you know if the person that facilitated the parenting time took notes or not?
I don't.
Okay.
$10.57.
Would you agree with me that Mr. Opatz didn't know the child was going to Ann Carlson? He wouldn't be able to attend those appointments?
I had told him.
Okay. Where in Exhibit 2 did you tell him about the Ann Carlson appointments?
I told him in person.
You haven't talked to Mr. Opatz since December of 2023. How many appointments has she had since December of 2023?
At least 12.
Okay.
But I wasn't.
Hold on. You're not asking questions and you answered mine. How many times have you told him about the 12 appointments? Since December of 2023. How many times have you told him about those appointments?
I was not there for all of them because I had to work also. My dad did.
And he didn't answer my question. Did you tell Mr. Opatz about any one of those 12 appointments?
No.
He wouldn't be able to go unless he knew about them. You would agree with me, wouldn't you? Yes or no?
You need to answer the question.
I'm breathing.
Okay. So answer the question.
He didn't know about them.
How can you expect Mr. Opatz to participate in something he doesn't know about?
Because he did not want to do her doctor's appointments.
But you didn't even give him the opportunity to say no, did you?
I did.
Not since December of 2023, you didn't, did you? Why didn't you tell him about the 12 appointments?
Because I didn't know when some of them were either, because my dad did some of them because I had to work.
So are you parenting the child or your parents?
My dad was watching her at the time for daycare because I had to work to be able to take and pay stuff for my daughter.
Then why are you holding against Zach since he didn't get to attend some of the appointments because he had to stay and work and you did the same thing?
Because I felt like it was better for me to go to work than miss a bunch of work.
Wait, this is a good time to take a break, Your Honor.
We're going to take a break. Ma'am, you are still under oath. I'm going to advise you not to discuss your testimony with any other person. We're going to take a 10-minute break. It's now 11 a.m. We're going to go off the record until 11:10. I'll ask the parties to be back by then. Thank you. We're off the record. Ready? All right, Sargent County District Court is now back in session this June 26, 2024. Time is now 11:11 a.m. We're back on the record in Witkowski versus Opatz, and the state of North Dakota as a real party in interest. File 41, 2023 DM 37. Parties are present, attorneys are present. We're in Sargent County Courtroom number 1. The door is propped open. The building is open. These are open to public proceedings. We're also live streaming the event on the Southeast Judicial District's live stream YouTube channel. Again, all parties are present. All attorneys that were previously identified are present, with the exception of Mr. Jung, whom the court excluded or excused. We were in the middle of Ms. Witkowski's cross-examination. Ma'am, you are still under oath. Ms. Witkowski is back on the witness stand and prepared to proceed. I'm reminding you, you're still under oath. Mr. Green found a convenient spot to start. Mr. Green, go ahead.
Thank you, Your Honor. In paragraph 15, you stated, I have provided KJO's schedule and her list of likes and dislikes to my attorney, who in turn provided to Zach through his attorney. What does this list look like?
It's got her day-to-day schedule of what she likes, what she does throughout the day.
That wasn't in your declaration though, was it?
I sent it with it.
But you didn't include the schedule as part of your declaration, correct?
I set the schedule with my declaration.
Okay, but the schedule is not set out inside of your declaration, correct?
I had it set with her, with all the paperwork, so it would be easier for him to read.
Okay. Why didn't you just provide it directly to Mr. Opatz?
Because I was doing what I was told.
All right. Are you aware that Mr. Opatz has completed 3 different parenting classes?
I
How many have you completed?
none.
In paragraph 16, you wrote, while I was with Zach, I was not the only person living in the home and the house was a mess. What are you discussing there? What's the purpose of that sentence?
There was his other daughter and him, and sometimes I would ask for help with cleaning, and he wouldn't.
When you were with Mr. Opatz, how many hours a week were you working?
I was working the 32 or more sometimes.
Okay. And you didn't have time to make sure the house was clean, so you asked Mr. Opatz for some help?
Yes.
Okay, and that was the purpose of that statement?
Yes.
Okay. Now, in paragraph 17, you discussed 2 different car accidents. How did the first car accident occur? What went on?
It was back in November 23, and power had gone out in Lisbon, so we were going to go to Gwinnett to stay warm because we didn't know how long the power was going to be out. And we're coming around the dead cold curbs, and a pickup in front of us fishtails, and he was going slow enough, but he hit the same black ice they did, and he hit them.
Okay. And did the airbags deploy?
No.
Was there pretty significant damage to your vehicle, Mr. Opat's vehicle?
Yes, there
And
was
where was that damage?
up front.
And can you explain to the court what that kind of looked like?
His hood was bent in. We could not get it open unless we pry barred it, and he had to replace his headlights.
Okay. And as a result, was your understanding then that a new car seat would be needed because of that
Yes.
impact?
Yes,
Okay. And now tell me about the second accident.
we were in Fargo, and we were in the lanes, and a car went to turn into the lane and hit us
Okay. Where did he hit you?
on the driver back wheel,
Okay. Was there significant damage?
just to the hub cover and the tire, and that's it.
Okay. Did the airbags deploy in that accident?
No,
And what was the damage to the car?
just on the wheel hub cover was broke, and there's scratches on the wheel.
Did the accident jar you in any way?
It did.
Was anybody injured?
No,
Okay. Why did you believe that a new car seat was needed after that accident?
because we were told that after any car accident, there needed to be a new car seat. Otherwise, insurance would not cover it.
Now, backing up to paragraph 15 here, you stated, quote, while I was in Zach's home, I paid bills and had them pulled out of my savings and or checking account. You wrote that correct?
Yes,
Do you have any evidence that you made those payments?
I would on my phone, but I do not have it with me right now.
Okay. You didn't present anything to the court that you did that, correct?
No.
Then in paragraph 18, you stated, quote, I offered to help pay bills, although Zach never opened the mail, end quote. I'm a little confused because one statement says you made payments, the other one says you offered to. Which one is it?
At first, I offered to pay, and then I started paying some of them.
Okay. When did you offer?
When I first moved in, from the beginning,
Okay, and then when did you actually start to pay?
I started in July.
Okay, when did you first move in? I should maybe ask that question too.
We were seeing each other beginning of January, and I didn't move in until August when I was pregnant with Cassidy.
Okay, and I'm sorry, I know you answered this, but your answer didn't stick with me. And when did you start paying bills?
And I actually start paying them in June or July before I moved in.
Paragraph 21, you wrote, quote, I have followed through with sharing information with Zach and his attorney by letting them know I was able to acquire my own apartment, end quote. When did you let Mr. Opatz know that you had gotten your own apartment?
I done it the way I was supposed to and sent it to my attorney who sent it to you, because that's how I was told to do it.
Okay. But you don't know if your attorney actually forwarded it to me, do you?
She said she did.
Okay. Would it surprise you to know that I've not received that until I got your declaration in this case?
She said she did send it to you.
And do you know why it hasn't been changed with the court yet?
I do not. I've submitted it.
And you would agree with me that you did not follow through with sharing information about the Ann Carlson appointments, correct?
He's been.
Correct. You didn't share those appointments with him, correct?
I didn't, because he was on the records and I shouldn't always have to.
That wasn't my question, though. My question was, you didn't share them with him, correct?
Mm-hmm. Yes.
And this is Ann Carlson, correct?
Yes.
Does Mr. Opatz I know you testified that you informed me, but would you be surprised to know that he didn't know that she was going to Ann Carlson?
I told him.
Paragraph 22, you stated, I would facilitate visitation with Zach and KJO if I could trust that he would not run off with her. You wrote that?
Yes.
Isn't that exactly what you did?
He has seen her.
You ran off with her, right?
He has seen her on FaceTime too, and with visits.
Did you take her?
I have her right now, but he has seen her.
Okay. Now I'm going to ask you if the shoe were on the other foot, how would you feel?
I would have done the same thing.
What do you mean by that?
I would have still video chatted with her if I could and seen her.
And despite 51 requests since December, how many times have Mr. Opat's been allowed to see her?
Two more, and the last time he tried to take off and run with her.
Your Honor, I moved to strike. She was not present at that. Were you present there?
No, because I had to work.
Move to strike that statement, Your Honor.
Your Honor, he asked the question and he got the answer.
No, I didn't ask her.
Then he objected on hearsay grounds, objection sustained. And motion to strike sustained.
In paragraph 24, I was a little bit confused about the entire paragraph. There was a statement within that paragraph that you said, quote, he did not give her a reasonable amount of time to answer as she had other children in her care and needed to tend them at that time. You wrote that?
Yes.
What were you talking about?
When I would have his other daughter and Cassidy at the same time, I would be trying to take care of them both, and he wouldn't let me get everything done
Okay.
with them.
So you were referring to, I'm a little confused. Your statement was he did not give her a reasonable amount of time. You're referring to yourself in the third person?
Yes, I mistyped that one
Okay.
with the her there.
You're not referring to his communication with the babysitter.
No.
Okay. And I asked that question because earlier in the paragraph, there was a discussion about his conversation with the babysitter. Then it moved into something else, and then you went back to this statement. So I was confused by it. But that was, you're referring to you.
Yeah.
Okay. Paragraph 28, you stated, quote, she has built a community here, and so her address for school should be my address in Gwinner, and she has built relationships with children in this community. What did you mean? What do you mean by, end quote? You said that first of all, right?
Yes.
What do you mean by she has built a community here?
She has built with made friends and has seen other adults that that enjoy being around her and want to see her.
So built a community as another reference, because at the tail end of that very sentence, you say, and as she has built relationships with children in this community. You're just basically restating the same thing?
She has built with friends that are kids.
Okay. Prior to you removing her from the Opats, the home owned by Mr. Opats, had she lived anywhere else?
Just there.
So you uprooted her from the only home that she ever knew and moved her into a new home, correct?
Yes.
And now you're asking the court not to uproot her again because you removed her from the only home she ever knew, correct?
Yes.
I don't have anything further, Your Honor.
All right. So the rule 8.2 is rather unclear on whether or not the court should allow redirect. What I will do in light of the procedural posture and in light of some of the issues raised in the declaration and cross-examination, the court's going to allow brief redirect and recross. So I'll give Ms. Chisholm an opportunity to ask some questions. And likewise, when the shoe is on the other foot, I will allow redirect and recross of Mr. Opatz as well. So Ms. Chisholm, go ahead.
Thank you, Your Honor. Kristen, did you file with the court, or did I file with the court on your behalf a confidential information form that provided your new address in Gwinner?
You did.
Okay. And that was served on opposing counsel?
Yes.
Okay. And you've had the opportunity to read and review Mr. Opatz's declaration in this case, correct?
Yes, I have.
And in his declaration, he references your new address, correct?
Yes, he does.
Okay. And he references that confidential information form, correct?
Yes.
Okay, so he was aware of your new address by
Mhm.
way of that confidential information form.
Yes.
With respect to a conversation that you and Mr. Opatz had at the time you ended your relationship, were there some concerning comments made regarding Cassidy?
Yes, there was.
What were those?
That he was going to take her and run, and that I was never going to get to see her again.
Okay. And how did that make you feel about parenting time?
Nervous.
Okay. And what did my office recommend as far as parenting time?
To do supervised visits for the time being
Until when?
until court
Or until what?
mediation, if we had resolved it in mediation.
Okay. And were you and Mr. Opatz able to get some kind of parenting time arrangement made between the two of you?
We tried a couple of times to get it arranged
And why weren't you able to?
because he wanted he was either 50-50 or
Your
full
Honor,
custody.
objection. Now we're getting into negotiations.
Sustained.
Your Honor, I believe the parties can discuss conversations between the two of them.
It's well beyond the information that was presented in cross-examination, so it's a scope issue. You objected previously on the basis of attorney-client privilege. I think this constitutes attorney-client privilege. I also think there are concerns with the court about being part of negotiations at this stage. So move along. I'm going to sustain the objection.
May I approach?
Yes.
Kristen, I've provided you with a text message conversation between you and Mr. Opatz. Do you recognize this conversation?
Yes, I do.
Okay. Do you recall the time frame of this conversation?
Before you get there, Ms. Chisholm, is this text message exchange different than Exhibit 2 that's already been received?
It is, Your Honor.
What is it? Identify it for the court, please.
It's a text message conversation concerning a parenting time exchange.
And where is it in the record?
It's not provided part of the record, Your Honor.
Okay, so the rule requires testimony and evidence to be presented by declaration. If it wasn't part of the declaration and it wasn't an exhibit to the declaration, why should I consider it now or allow you to question it under Rule 8.2 or question about it under 8.2?
Because it's rebuttable evidence, Your Honor. My understanding is we are allowed to provide rebuttable evidence.
Mr. Green?
Your Honor, let's just allow it. I'm not going to put up a fight on this text message.
All right, ask your question.
Kristen, do you recognize this?
Yes, I do.
Okay. Do you recall the time frame of this?
It was in May.
May of this year?
Yes.
Okay. And in this text message conversation, are you offering Mr. Opatz parenting time?
Yes, I am.
Okay, and what kind of parenting time are you offering him?
I was allowing supervised visits or every other weekend.
Okay, and what was his response?
That he would not agree to it. He wanted 50 or full custody.
That he's only settling for 50-50 or full custody?
Yes,
Okay, no other type of parenting time.
yes.
Your Honor, I'd ask that the court receive plaintiff's proposed Exhibit D.
Mr. Green,
I'm going to object, Your Honor. Not because of the exhibit itself. There's already an Exhibit D in the record, and we've encountered this problem before. And so Exhibit D would not be acceptable, but if she wants to call it something else, I will not object.
I'm going to relabel it 101. So 101 is received.
Kristen, just briefly with respect to the IMA healthcare records, is Mr. Opatz, his name listed on those records?
Yes, they are.
Okay, does he have access to that?
Objection, Your Honor. Those records haven't been provided, and even if they had, they don't have anybody here to authenticate those records, so that she lacks foundation and it's hearsay.
Ms. Chisholm?
It's a simple question as to whether or not he's listed on those records or has access to them.
And what foundation was laid with respect to whether or not he has access to them? So I think that was the basis of Mr. Green's objection, is a lack of foundation and a lack of authentication.
Well, certainly she can testify as to whether or not she put his name on the records.
That wasn't the question.
Sustained.
Kristen, did you put Mr. Opatz's name on the IMA healthcare records?
Yes, I did.
Was he present at the time?
He had chose to work instead of being at her doctor's appointments.
Did you put Mr. Opatz's name on the Ann Carlson records?
Yes, I did.
And so he has access to those?
Yes.
Objection again, foundation.
Sustained. For the same reason.
And Kristen, I know this has been belabored, but you did inform Mr. Opatz of the Ann Carlson
Yes, I did.
involvement of Cassidy. With respect to offering parenting time, how many times since September have you offered parenting time to Mr. Opatz?
At least 3 to 4 times.
And there's been other forms of communication between you and Mr. Opatz?
Just through Messenger.
And has Mr. Opatz sent Christmas gifts or birthday gifts?
No, he has not.
Okay. And outside of diapers and wipes, has Mr. Opatz provided any financial support?
Only to pay daycare for a little bit.
And has Mr. Opatz provided you a copy of the insurance card?
No, he has not.
Did you even know he had insurance on Cassidy?
I did not.
What sort of health problems was Cassidy born with?
She had a collapsed lung because her
I'm gonna
larynx.
object. I didn't get into this in my cross-examination. It's outside the scope of cross.
Your Honor, I believe there was a reference to a collapsed trachea in response to one of Mr. Green's questions.
I recall the testimony that there wasn't reference to a collapsed trachea. It was a weak larynx, was the testimony that the court received. The court is going to give you very limited scope and range here. This was not the focus of Mr. Green's cross-examination, so get to the point very quickly, Ms. Chisholm.
Can you answer the question, Kristen?
She had a collapsed lung because she took a big breath of air when she was born because her larynx was weakened and underdeveloped.
And does she continue to doctor for those issues?
She has been cleared from her ear, nose, and throat, but if we notice a problem later on, he told us to come back.
I don't have any additional questions, Your Honor.
Mr. Green, any redirect, or I'm sorry, not redirect, recross.
One moment, Your Honor. Yeah, I just have a couple questions. I'm going to have you turn to Exhibit 101. You have that in your hand?
Yes, I do.
Okay, great. Your testimony earlier, if I'm not mistaken, was that Mr. Opatz refused visitation or parenting time unless it was 50-50. Was that your testimony?
Yes.
Okay. Where does he say he'll not exercise parenting time in Exhibit 101?
He said he's,
Hold on, I'm not finished. In 101, that he will not exercise parenting time unless he gets 50-50.
on the first page where he says he does not agree to that with what I said.
He wrote, I will not agree to that 50-50 or I'll be going for full custody. How does that state that he's unwilling to exercise parenting time?
I took it as he was not wanting to do visitation because he wanted the 50-50 or full custody.
And is this the only evidence that you would have where he said he doesn't want to exercise his parenting time?
God, I have a disease. It would be.
Nothing further.
All right, ma'am, you can step down, but I need Exhibit
There you
101.
go.
Reports received 101. Madam Clerk. Thank you. All right, Mr. Green, any other witnesses, evidence, or testimony for cross-examination?
Not for cross-examination, Your Honor.
All right, so I can treat that as you resting at this point?
Yes.
Ms. Chisholm.
Just briefly, Your Honor, with respect to offering exhibits, how would the court like to handle that?
I think in light of the new case law that I'm required to follow, they have to be introduced. Although they've been filed, the declarations have been filed. They are part of the case record, not the evidentiary record until they're offered and received. So it makes these hearings interesting. It makes taking judicial notice of these things interesting.
It does.
But nonetheless, that's how I'm interpreting that recent case law, is that you must offer them and then I must consider them individually.
So then I have one follow-up with respect to my client, and that would just be the photographs in Exhibit A, Your Honor. And then the Exhibit B that was referenced in her affidavit, and I don't know if opposing counsel has any objections to those or not.
One moment, Your Honor. A and B. Your Honor, with respect to Exhibit A, no objection. With respect to Exhibit B, it appears to be a statement not made under oath, and therefore I would object on that ground. Nor is it incorporated by reference in her declaration.
Ms. Chisholm.
My client testified that that's a document that she put together as a layout of their child's day-to-day basic needs. It was a document that she created for Mr. Opatz's convenience. I don't know how else we could have referenced that.
She could have incorporated it by reference, Your Honor, into her declaration, which is a sworn statement, well, an unsworn statement, but it falls within the parameters of Chapter 3115, because she states at the bottom, I declare under penalty of perjury, the foregoing is true and correct. This particular document is not incorporated by reference. Therefore, it is a unsworn statement that does not comport with Chapter 3115.
All right, Exhibit A, which is Record Index 55, is received without objection. Exhibit B. There was very little foundation laid with respect to Exhibit B. It's not incorporated by reference. It's unclear who prepared it. It's not sworn under oath. It's not in the form of an affidavit. It's not in the form of a sworn declaration. It's unsigned. And it doesn't include language that it's being submitted under penalty of perjury. The court is going to exclude and not admit Exhibit B, which is Record Index 56. Ms. Chisholm.
Your Honor, I would call Zach Opatz.
Mr. Opatz, please come forward. Mr. Opatz, you were previously placed under oath When we asked questions about child support, you remain under oath. Have a seat in the witness chair. Go ahead.
Mr. Opatz, what are your work hours at Bobcat?
7 to 3. 7 a.m. to 3 p.m.
And how many days a week?
5. Unless we're posted for Saturday.
Okay. And do you have a daycare lined up in the event that the court were to award you some form of residential responsibility?
Yes.
Okay, and who would that be?
I didn't mark it. I didn't give them the information, but her name is Brianna Monroe.
Okay. And you've already talked to her and made arrangements?
Yep.
Okay. And she has availability?
Yep.
Okay. And who watches your other child?
She stays at home. She's 11. And my parents live a block away from us, so she can just go there.
Okay.
And then she has phone numbers to get in contact if she needs something.
Okay. And your 11-year-old, the mother is Elizabeth Opatz?
Elizabeth Freeze.
Okay. And you were married to her at some point?
Yep.
Okay, and that would be the divorce from approximately 10 years ago?
Yep.
And that was the same time you did
Your Honor,
all of
I'm going to
those?
object. This is outside the scope of the declaration of Zachary Opatz.
Ms. Chisholm, where is this in the record?
Your Honor, it's in reference to the parenting classes that he took at the time of his divorce.
The court is going to sustain the objection with respect to the divorce. If you have questions specific about parenting classes, those are things that you can ask because they were raised and they were filed as exhibits. But general questions about the divorce from 10 years ago involving a different party, the court's not going to allow. Go ahead.
Mr. Opatz, did you do parenting classes as part of your divorce?
Yes.
Okay, and those would be the parenting classes attached as exhibits to your affidavit?
Yep.
With respect to any recent parenting classes in regards to Cassidy, you haven't done any, correct?
No.
Were you aware while you and Ms. Witkowski were in a relationship that Cassidy was attending doctor's appointments at IMA Healthcare?
I knew about doctor's appointments when Kristen and Cassidy were living with me, but after that, she would not tell me anything.
And so you were aware that they were attending appointments at IMA Healthcare?
Yes.
So you
I
had-
didn't know the name. All I knew it was just the doctor's appointments.
And that was while she was still living with you?
Yes.
Did you ask Kristen where she was taking your daughter?
No.
You weren't interested in being involved,
Yes.
but you didn't ask.
No.
And during one of the visits that you had at the church, you were informed of Ann Carlson, correct?
No.
You don't recall that conversation?
I don't recall.
Have you asked Kristen about any appointments regarding Cassidy?
No.
Why not?
Because it goes both ways.
So she is required to tell you, but you're not required to ask?
How would I know about the appointments if she doesn't communicate?
Well, you could ask, correct?
But she ignores me.
As far as your requests for parenting time, you've indicated that you're not going to agree to anything less than 50-50, correct?
I'll agree to 50-50. And that's it. If she doesn't want to agree, then I'll go for full custody.
And you're not interested in exercising any other kind of parenting time other than the 50-50, correct?
I'll work out whatever needs to be done for Cassidy.
But it has to be a 50-50 arrangement, correct?
Yes, that is the only way that is fair.
Ms. Chisholm, I'm going to stop you there and ask a clarifying question. Because I think these terms are being used interchangeably and I'm not so certain that they should be. When you talk about parenting time, Do you mean visitation? Because 50/50 refers to primary residential responsibility, not parenting time. Are you treating those things interchangeably when you're asking Mr. Opatz these questions?
I'm referring to the time that he wants to spend with his child.
Okay. So when you say 50/50, you mean 50/50 parenting time,
Correct.
not 50/50 residential responsibility. I think Mr. Opatz is referring to full custody in terms of primary residential responsibility. So if you can clarify those when you're speaking with one of the parties, I would appreciate it. I think he's not understanding your questions. Go ahead.
Mr. Opatz, when it comes to residential responsibility or custody, what is it that you're seeking?
Primary custody.
Okay.
So I have primary custody of my oldest, and it would be nice to have her with her sister.
Okay. And as far as parenting time with Cassidy, what are you seeking?
I want the primary but she can get the every other weekend.
Okay.
Until we can figure it out when she gets old enough to go to school.
Okay. And you and Ms. Witkowski have had many conversations about parenting time, and you've indicated in Exhibit 101 that you will not agree to that, correct?
Yes, I said I don't agree to what she said, but 50/50 or I want to go for full custody.
So were you saying you didn't agree to the visitation?
Yes. Well, I agreed to the visitation, but I don't agree to what she wants.
So there was maybe some confusion on both of your parts in that text message. You were not agreeing to her being the primary custodial parent, but you were agreeing to her visitation. Is that a fair assessment?
Yes.
So as far as visitation over the span of the last several months, what would you have been willing to agree to?
Can you repeat that, please?
As far as visitation or what we call parenting time, what would you have been willing to agree to?
The 50/50?
Okay. It still would have had to have been equal.
Yes.
Okay.
Because it's fair to Cassidy for her well-being and keep the bond with both parents.
And so if she would have offered you say a weekend, you would have said no.
I would have said yes.
You would have said yes. You would have taken a weekend.
Yes, and I've asked her that, and she would not respond.
Okay. And would you have just exercised the weekend, or would you have kept Cassidy for the week?
I would have kept her for the weekend.
Okay. And then returned her?
Yes.
So I think then maybe there's some confusion about what the two of you were discussing. Now, you had a recent visit in May, correct?
Yes.
Okay. And how did that go?
Objection, Your Honor, outside the scope of this declaration. This declaration was drafted prior to that incident, Your Honor.
Declaration is signed May 9. Clarify your question, Ms. Chisholm, on whether or not you're talking about something before or after the declaration was signed.
Mr. Opatz, when is the last time you had a visit with Cassidy?
May 10th.
And that would have been the exchange.
Yes.
And prior to that, when did you have a visit?
I think it was I don't know on the top of my head.
Now, while the two of you were still under the same roof, Ms. Witkowski was the primary caretaker for Cassidy because you were working, correct?
Yes, I was working and taking care of the housework.
Okay. And she was addressing the food and the basic necessities of Cassidy, correct?
We talked about what stuff she needed.
Okay. And you recognize that Cassidy has some deficiencies, some developmental deficiencies, correct?
Not that I noticed.
Again, Your Honor, I'm going to object. That's outside the scope. We didn't talk about that in his declaration.
I will overrule the objection, but I'm going to give you limited scope here. It's not in the declaration, Ms. Chisholm.
So you said not that you're aware of?
Yes,
Have you been told that she uses sign language?
not that I'm aware of.
You have provided some Facebook pictures or some pictures as part of your exhibit. Where did you get those from?
Which pictures are they?
The pictures that you attached as an exhibit.
Am I able to see the pictures?
Well, they're your exhibit.
Oh, my exhibit?
Your exhibit.
Okay.
Did they come from Kristen's Facebook?
She tagged me in them.
Okay, so she took the photos?
Yes, or somebody else did.
Okay. And with respect to family environment, you were close to Kristen's parents, correct? You had a good relationship with them?
Yeah, I was always respectful to them and helping them out every way I can.
Okay.
When their pickup broke down, Robin called Kristen and I dropped everything I did and to go help.
Okay.
And then my stepdad helped and he towed their pickup into town.
And they've helped you
Yep,
with money and fuel oil and a car and fill out paperwork and other things, correct?
not money, but we help each other out.
And they've been very active in your daughter's life,
Yep.
both of your daughters'
In
lives.
Chris's life, and I really appreciated that.
Okay. Yep. And obviously, Cassidy has now been in the Gwinner community for some time, correct?
Yep,
Okay, and she's involved in the Ann Carlson appointments there, correct?
that I didn't know.
Okay. And as far as any type of dangerous environment in Kristen's home, you don't know of anything along those lines, correct?
No clue.
Okay. And you don't have any concern that Kristen isn't a good mom, correct?
I don't know.
Your biggest gripe is that she's supposedly been alienating you from your daughter, correct?
Yes.
That's your biggest complaint?
Yep.
Well, you can understand why she would be nervous when you threaten to withhold or keep the child if she moves out, correct?
I wouldn't do that. I never threatened her with that.
Are you aware that some of your family members also said similar things?
Not that I'm aware of.
As far as contributing financially, is there a reason that you haven't provided anything more than diapers and some wipes?
I have stuff at my house. Since she's parental alienating me, I'm gonna buy stuff for my house.
Is there a reason that you didn't send a birthday card or a birthday gift?
It's all at my house.
Okay, Christmas gifts at your
Yep.
house?
Because
You-
since we're split, whatever she buys for Cassidy stays with her. Whatever I buy stays with me.
Okay. And you apparently have health insurance for Cassidy.
Yes.
Is there a reason that you haven't provided Kristen notice of the health insurance?
She didn't let me know of anything for Cassidy, so it goes both ways.
Well, you were aware she had medical assistance, obviously.
Yes.
She had it while the two of you were together.
Yep, I was aware of that, and then Kristen told me not to put Cassidy on my insurance until after we got married.
Okay. If I may have just one moment, Your Honor. And you have a driver's license
Yes.
and a vehicle?
Yep.
I don't have any additional questions, Your Honor.
Mr. Green, as I gave Ms. Chisholm an opportunity to redirect, I'm giving you the opportunity to redirect your witness.
Thank you, Your Honor. Oh, sorry. Yep. Thank you. Mr. Opatz, do you have a telephone number for Ms. Witkowski?
No.
Your Honor, I'm going to object. That's outside the scope.
In her declaration, Your Honor, it states that they have trouble communicating. I would submit to the court that part of the problem is that Mr. Opatz does not have a telephone number for Ms. Witkowski.
Your Honor, again, it's outside the scope. That argument has been raised many times.
I'm going to sustain the objection.
Well, and it also goes to Your Honor, why he hasn't, she talked about why he hasn't conveyed the information about the health insurance card. That would have been a means of doing so. But I understand the court's sustaining of the objection. I want to go back and talk a little bit about the parenting time thing because I'm a little bit confused by it. Hopefully, I won't be when I'm finished here. Did you ever tell Ms. Witkowski that you would not exercise parenting time if she didn't just do 50-50?
No.
And you're amenable to 50-50 even here today, aren't you?
Yes.
Do you think that you should get some makeup parenting time since you've gone without for so long?
Yes.
Now, I'm going to have you grab the exhibit book behind you there.
Which book, Mr. Green?
I'm sorry, my exhibit book, our exhibit book, the white one.
The white one?
Yep.
Thank you.
So the book that you have in your hand are defendant's exhibits. Permission to approach, Your Honor.
Granted.
Mr. Opatz, can you tell me what exhibit 15 is?
Asking Kristen if I can get Cassidy.
Not
the
the
weekend.
contents of it. What is it? Is it text messages or what is it?
Yes, it's text messages from Messenger.
And this is between you and Ms. Witkowski,
Yes.
and this is from April to June of this year.
Yes.
I'd offer exhibit 15.
I'm going to object. It's outside of the scope and it's beyond his affidavit or his declaration, the dates. The court has specifically limited our conversation or discussion here today to the contents of the declarations, which very clearly ended May 9th.
I'm going to sustain the objection and not receive exhibit 15. However, I believe the door has been opened enough for Mr. Opatz to testify about requests.
Okay.
So I think he can testify about it. I'm not going to allow the exhibit at this point.
Okay, thank you, Your Honor. Mr. Opatz, how many times have you asked for parenting time?
Over 50 times.
And do you get responses?
No. She reads them and ignores it.
Do you get responses when you ask her if she needs anything?
Yes.
How quickly?
Within pretty short of time.
So she does receive your messages, correct?
Yes.
All right. And have you ever learned about any single appointment in Ann Carlson?
No.
Do you think that your daughter deserves to have her father know about those appointments?
Yes.
Do you think your daughter deserves to have a relationship with her father?
Yes.
Do you think that it was harmful for her to not see her father for such a long period of time?
Mentally and emotionally, yes.
I don't have any further, Your Honor.
Recross, Ms. Chisholm.
Did you come to Kristen's residence to see Cassidy?
No.
Did you come to Kristen's parents to see Cassidy?
No. Because after we split, I didn't want to cause any problems. And from what I have noticed before with Dave, he's never liked me, no matter how much I tried to be polite.
I don't have any additional questions, Your Honor.
All right, sir, you may step down. Ms. Chisholm, any other witnesses, evidence, or testimony?
No, Your Honor.
All right. So, Mr. Green, I'll hear closing arguments from you, then I'll hear from Ms. Chisholm, then Mr. Green. I'll give you the final word, and then I will take the matter under advisement as I've informed Mr. Jung that I'm not going to have a decision for you today. So go ahead.
Well, Your Honor, at the beginning of this case, I informed the court what I fully expected to lay out, and I think I have largely accomplished what I said I would accomplish in my opening remarks. The same cannot be said of the opposing party. The basis for withholding the term that was used in the opening remarks was harm. Can't let him see him because of harm. This court didn't, there was nothing even in the declaration about harm other than she felt it was harmful for Zach to withhold, that would be harmful for Zach to withhold the child. So what does she do? She withholds the child. She acknowledges that that's harmful to the child and then does it. We don't know what Mr. Opatz would have did because, well, it would all be speculation. He was never given the opportunity. But it seems oftentimes attorneys advise their clients to withhold the child, not thinking about the best interest of the child. And yet Ms. Witkowski has the audacity to sit in her statement to say that Mr. Opatz is harming the child. There's no harm here, Your Honor. Mr. Opatz hasn't harmed the child. Ms. Witkowski has. She has alienated this child. Her conduct supports it. She is going to hold Mr. Opatz to a much higher standard than she holds herself. Mr. Opatz should reach out to Ms. Witkowski for KJO's appointments. That makes no sense, Your Honor. Makes none at all. He doesn't know when those appointments are. He doesn't know how often they are. It makes zero sense whatsoever. But I think the court needs to go through Ms. Witkowski's declaration with a fine-tooth comb. I've done it today. There are a number of statements in there that make absolutely zero sense. There's contradictory statements. Any reference to a problem in the relationship, the finger is always pointed at Mr. Opatz. Now, today, I believe Ms. Witkowski stepped back from that and acknowledged today that it takes two to tango, two to have an argument, so to speak. But that's not the way her declaration was written. Her declaration was written completely one-sided, and I understand this is an adversarial process, so that's what oftentimes happens. But one must be careful when drafting these declarations to not overstep the lines between something that is truthful and something that is not. And I would submit there are a number of statements in here, Your Honor, that cross that line. I went through basically almost paragraph by paragraph and picked out things for this court in her testimony or in her declaration that demonstrate the inconsistencies in her statements, the inconsistencies in the standards that she holds Mr. Opatz to as compared to the standards that she holds herself to with respect to their daughter. The bulk of her declaration, one of the reasons I had to ask so many questions today on her declaration is there were a number of self-serving statements that lacked specificity. No dates, no times. He just said this. When? Why? A number of statements that were not backed up by evidence. Self-serving statements not backed up by anything other than her declaration alone. It is unclear to me in Exhibit 101 how you can read this and say that I am unwilling to exercise any parenting time unless we have 50-50. I can't read it, but maybe I'm wearing rose-colored glasses or the opposite of that and can't see that because I'm so focused on wanting the best for my client and the daughter. But I don't know how the court could possibly read anything into that other than, look, I am not going to start doing weekend parenting time because that's what you want to impose on me, or supervised parenting time. I was recently at a hearing where an attorney argued, if you do accept that, it's like you're acknowledging that that's appropriate. And there's some truth in that, I believe. I give you one example of the double standard that I'm talking about. Mr. Opatz can't go to doctor's appointments because he needs to work because they're short on cash. She says in her own declaration, she testified to it today, they're short on cash. And then she testifies today, now that she has the child in her own care, that she can't even attend some of the appointments because she has to work, so her father takes the child. That's a double standard. You're going to use that against him on the one hand, but you're now doing it yourself. This court has the ability to look at witnesses' demeanors and decide whether they're being truthful and determine a number of different things. And that's why courts have the parties testify in person and oftentimes even have the witnesses. That's why that's the preference. I think if the court looks at the demeanor of the two parties in their testimony today, there's a stark contrast in the way they testified. On the one hand, you have Mr. Opatz who remained calm, collected. None of the information was subject to recall. He fired his answer back as soon as the question was done. In contrast, Ms. Witkowski is staring back at the audience. She's struggling to answer questions. Her answers are subject to recall. And at times, she struggled controlling her emotions and needed to pause and breathe. Court has to wonder what happens when she's got a screaming kid or other things are distracting her or creating conflict in her life. Does she need to stop and breathe then? Mr. Opatz is indicating today that he's willing to do 50-50, but I quite frankly disagree with him. I think he should have temporary primary residential responsibility. Now, obviously, Mr. Opatz's opinion weighs more heavily than mine on this court, at least it ought to, but let me just explain why I think Mr. Opatz should have temporary primary residential responsibility for the interim period. And that's because she's alienated this child from Mr. Opatz. Didn't provide him with anything. No evidence to support any of the statements that where she claims I gave him this information. But what we do have is a very, very serious pattern of not responding to text messages when Mr. Opatz asks about parenting time. That supports the conclusion, and not telling him about Ann Carlson appointments. Instead, they try and flip that onto Mr. Opatz. He should have asked her that. He doesn't know when they are, Your Honor. That's another element to alienation. She doesn't want him to be a part of any of that. Just as she didn't want him to exercise any parenting time. But I'm actually focusing on the wrong thing here, Your Honor. This isn't even about Mr. Opatz. This is about KJO. What she did to Mr. Opatz, she also did to KJO. She denied KJO a right to have a continuing relationship with her father, a right to be reared by her father, and a right to be grown up and given advice by her father. She's denied KJO the ability to express her love, affection, and guidance from her father, Mr. Opatz. That's what she's done. And she's done that out of fear that Mr. Opatz may have done that for the child. Out of fear. Out of a statement that she claims he made at the time or near the time that the parties went their separate ways. Just no proof of that. Your Honor, I'm asking for the relief largely set forth in the order I've submitted as Exhibit 1. I didn't offer it as an exhibit, but it's filed as a proposed order anyway. So I'm offering with a notable exception. I don't even recall if I asked for primary here, but I'm asking that the court award either temporary primary residential responsibility to Mr. Opatz, subject to some parenting time with Ms. Witkowski. And the alternative, if this court is more inclined to do a 50-50 parenting time, Mr. Opatz seems to suggest that would work for him. I do believe that Mr. Opatz should have some ability to request some additional days during the interim period. Maybe not set them in stone, but allow him to have an additional weekend here or there, given that he has been denied parenting time for as long as he has. Nothing further. Thank you.
Thank you. Ms. Chisholm.
Thank you, Your Honors. The court is aware interim relief is within the constraints of North Dakota Rules of Court 8.2. This looks at what is in the best interest and welfare of the child. And what opposing counsel is asking this court to do is to take the child away from what a parent who believed they were acting in the best interest of a child out of punishment and out of spite. And then in essence, punish my client by placing the child with Mr. Opatz, not because it's in the best interest of the child, because I believe a review of the best interest factors weigh heavily in support of my client, but just simply out of spite, because my client has supposedly alienated Mr. Opatz. But if we look at the facts, Mr. Opatz made a very telling statement during examination when I asked whether or not he was interested in or asked questions about being involved in Cassidy's healthcare while the parties were together. And his response was, well, I never asked, and I guess I really wasn't that interested. That was his statement. That speaks volumes about his attitude as a parent, even when the child was in his home. So to place the sole burden on my client that she hasn't involved him, she's intentionally alienated him from being involved in these activities, things of that nature. This is a child who Mr. Opatz was very well aware was born with the healthcare issues that we discussed. He was well aware that she was doctoring for these things. And he still took no interest in it because it was my client's responsibility. And then suddenly when their relationship goes south, she leaves the home. Then all of a sudden continues to be my client's responsibility to spoon feed him this information. Well, he was on the paperwork. He had the ability to call, make some phone calls, to be an adult and to be involved on the behalf of his child, but he wasn't interested in doing that when the child was in his own home. So why would he be interested now that the child's not in the home? We also have a parent who unfortunately was dealing with some repercussions of making a statement in relation to keeping a child from the other parent. Now, we all say and do things that in hindsight, especially as clients, young clients with a young child, say and do things that have repercussions. But the statement that Mr. Opatz made to Ms. Wiskowski in relation to withholding the child had some very long-term effects with regards to parenting time. Now, obviously, Mr. Opatz had the ability to bring his interim motion well before he did. He waited until May to bring that motion. That was his choice. I would assume there was a reason behind doing that. But he certainly had other options available to him to seek parenting time long before he did, if in fact he believed he was being alienated, as he alleges he was. My client indicates that she offered parenting time that she was comfortable with. He had the ability to communicate with her. The court has received multiple exhibits that outline parenting time requests and communication between the parties. There was videos that were sent of the child learning to walk behind an A-frame walker. There was communication between the parties about COVID testing and well child visits, things of that nature. My client testified she informed Mr. Opatz of the Ann Carlson intervention. He could have certainly reached out to Ann Carlson and gotten information about appointments. He has health insurance. He certainly has the ability to reach out to the healthcare provider. He has her address. He could have went to her home. There's not a no contact order here, Your Honor. There's nothing preventing these parties from having communication. He indicated that he had a good relationship with her parents. He could have reached out to her parents. This is simply a situation where we have a level of distrust and some miscommunication about parenting time, Your Honor, that has caused these two parties to go some time without a set parenting time schedule. Unfortunately, in these types of situations, it's not uncommon for these types of scenarios to play out. Now, thankfully, it's been a relatively short amount of time in comparison to some cases. We'll get a year down the road where there's no parenting time schedule. But in this particular instance, Your Honor, the court does have to look at the best interests and welfare of the child. And in light of this child having some motor deficiencies, some developmental deficiencies, we do believe it is in the best interest of this child to be in Ms. Witkowski's primary care, subject to a set parenting time schedule for Mr. Opatz. I have no doubt that he loves this child and that he wants to be involved with this child, and that it is in the best interest of this child to have a relationship with Mr. Opatz. But this is a child that does need structure, consistency, and stability. And I don't believe that the Supreme Court has agreed that it is not in the best interest of a child of this age to be bandied back and forth on a 50-50 basis. This is a 1.5-year-old child and a child that does have these deficiencies, Your Honor. So I would suggest that a 50-50 schedule is not in the best interests of a child of this age. Also taken into consideration, the parties do live in two different communities now. Lisbon and Gwinner are obviously not that far apart, but they do live in two different communities. With respect to compensatory parenting time, I don't know how that works with a child of that age in this type of a scenario. Obviously, Mr. Opatz is going to have some time to rebuild his relationship with a child, but children of this age are resilient. It should take a short amount of time to rebuild that relationship. And based on the review of the best interest factors, Your Honor, we are asking that the court grant Ms. Witkowski's request for interim relief and award her temporary residential responsibility subject to a reasonable and liberal parenting time schedule for Mr. Opatz, which would include alternating holidays and an implementation of a child support obligation based on Mr. Jung's calculations. Thank you.
Mr. Green, you filed the motion first, so I'll give you I'm going to give you both an opportunity to give me a very brief rebuttal. So, Mr. Green, your motion was first. You can give me your rebuttal, and then Ms. Chisholm will be given an opportunity to give me her rebuttal with respect to the counter motion. So go ahead, Mr. Green.
Thank you, Your Honor. Your Honor, my client has laid out the best interest factors. And again, look at the demeanor of the two witnesses here today and assess their credibility on the stand. That's what this court has to do. And give weight to these various, both parties' analysis of the best interest factors. And I think when the court does that, it's very clear that many of these factors are probably neutral, but at the end of the day, ultimately, they favor my client. I didn't focus on all of the best interest factors when I did my closing. I focused on the fact that there's parental alienation here, and that's extremely harmful to a child. Even Ms. Witkowski indicated it's harmful to a child. She was afraid that Zach would harm her. What do you mean by that? I asked her. She said, I was afraid he would take the child from me. So what you're saying, I asked her, what you're saying is when a parent denies another parent the time or the child an opportunity to visit with the parent, that's harmful to the child. Yes. And then I asked her again, well, isn't that what you did? And she said, yes. How do you argue it's harmful and then go ahead and do it? On the advice of counsel? Is that our shield now? You take counsel's advice over the best interest and welfare of your own child. When you know better, you testify that you knew it was harmful, but that's what you were told. So you put the advice of counsel first. Makes no sense, Your Honor. There were, again, we go back and forth on this, but first of all, there's some mischaracterization of the evidence. In her closing, opposing counsel argues my client was very aware of all of the child's ailments. No, that wasn't the testimony. That was not the testimony, Your Honor. My client acknowledged the larynx at birth, and only then. He didn't acknowledge, he doesn't know about any diagnosis from anywhere else. There was no testimony to that. It's not in his declaration. He didn't talk about it under cross-examination. That's their narrative, but that's not the truth. One, we could sit and go tit for tat as to whose responsibility it is, but my client testified that he did not know about Ann Carlson, period. How would he know to go to Ann Carlson to get records, even if she did put his name on those records? How would he know if he didn't know about it? He wouldn't be able to, Your Honor. If even at one time, Your Honor, just one time, from the time that they separated, Miss Witkowski said, hey, she's got an appointment at Ann Carlson. Now he would have been on notice. We don't even have that. The fact that we've gone since September 2023 until now without even one single notification that she's going to Ann Carlson or that Ann Carlson's coming to the home, however it might work out, the fact that we don't have any of that since September 2023 should suggest to this court that Miss Witkowski is not being honest when she says that she informed Mr. Opatz. On cross-examination, Ms. Chisholm said, you knew about it because you were told about it at the church, right? He said, no, I didn't know about it. He didn't have to wait. He was not subject to recall. He didn't have to stare the judge down and tell him he's breathing. He just answered the question. Why? Because he's being honest. He's not trying to tell, he even admitted things that I'm like, boy, that didn't help our case. But that's just because he's being who he is, honest. There's some innuendo that went into Ms. Chisholm's closing argument. He could have brought this motion sooner. There was no testimony about his financial circumstances or why he had to wait. That's innuendo, Your Honor. She doesn't know. There's no evidence before this court about why Mr. Opatz had to wait. Your Honor, I would submit the best interest and welfare factors do not support awarding Ms. Witkowski primary residential responsibility. They support that Ms. Witkowski will do whatever she can to ensure that Mr. Opatz cannot participate in this child's life. She's offering, after keeping the child from him for the last 7 months, largely keeping or having it on her own terms, she wants him to have the minimum amount of parenting time. That alone should send a message to the court is she wants to continue to alienate this child from her father. I've asked for the every other weekend because my client hasn't seen the child for a while, and it's time, and between now and the evidentiary hearing, it's time for them to build that relationship between one another that Ms. Witkowski denied. For that reason, I'm asking the court to adopt my interim order, subject to what I said earlier. Thank you.
Thank you. Ms. Chisholm?
I would just comment on Ms. Witkowski's credibility, Your Honor. I don't think it's uncommon for a young mother who is a first-time mother to be emotional on the stand when talking about a child. And I don't think it's uncommon, based on this court's experience in the courtroom, for witnesses to be nervous or emotional when testifying. I don't think that's a sign of lack of credibility. So that would be my only rebuttal statement, Your Honor.
Thank you. As I've said now a few times today, I often rule from the bench in these cases when it comes to an interim order here, because I'm going to be waiting on Mr. Jung's calculations. I'm going to take the matter under advisement. I will have a written order out as soon as possible. My expectations are that it will be within the next 2 weeks that I'll have a written statement or a written order out. Sooner the better. It will depend on how long it takes Mr. Jung to get me his portion concerning child support. And again, the court has intentions on getting this out fairly quickly. I do note there is the 4th of July holiday that is sandwiched in that time frame. And the court has some personal business that's going to result in me being out of the office for a while, but I think 2 weeks is a reasonable estimate of when you should expect an opinion. So again, the matter's going to be taken under advisement now. And we are adjourned in these matters at this time. And again, expect about 14 days before you see that order. Sooner if I can get it out, but
So the first thing is it ethical for an attorney to tell a mom to withhold the child from their father? Is that an ethical thing to do? For some reason, I doubt it. He's got no domestic violence. They haven't alleged drug use. He's not wanted by the police for any reason. There's no reason that he should not be able to be with his child 50% of the time, except for mom is insecure about it. Or maybe her parents are insecure about it, which, they aren't part of the relationship. They aren't part of these proceedings. And every time she said we, we did this and we did that and we want to do this, I kept thinking, who's we? It should just be her. But she's still hanging on to mommy and daddy for guidance, I guess. Anyway, I wish we'd found out his ruling. He's going to rule in the next 2 weeks. We probably will not know what that is, and I'm sorry about that. But I thought you guys would want to see it. Thank you guys so very much for watching, and I'll see you next time.